judgment has been reserved in the Constitutional Court on the matter of the definition of consent. This is under the Sexual Offences Act. Now, acting for the Embrace Project, Advocate Nasreen Rajab-Budlender told the Constitutional Court that the landmark case about consent highlights deep flaws in how sexual consent is interpreted in law. Rajab-Budlender has argued that the current system continues to fail survivors and undermines justice for the victims of gender-based violence. In terms of the Sexual Offences and Related Matters Act, a person charged with rape can avoid conviction if they can show it is reasonably possible that they believed the complainant had consented to sex. Now, this defense does not require showing that consent was actually given. Last year, the High Court in Pretoria ruled that certain provisions in the Sexual Offences Act were unconstitutional because they failed to protect victims. Rajab-Budlender says they seek confirmation of the High Court's order. All right, let's get you more now on what came out of that court argument. In studio with me is my colleague, Zoleka Qodashe, who has been following the proceedings. Zoleka, good evening to you. Let's start with the summary of the key points. I'm sure it was a whole day of discussion, but a very important matter indeed.
That's right, Koli. And essentially, as you correctly mentioned, the applicants seek confirmation of the Declaration of Constitutional Invalidity that was granted by the Gauteng High Court in Pretoria last year. But I think it's important for us to personalize the matter. One of the applicants, the second applicant, her name is Inge Holstendragen, and she essentially was an alleged victim of rape in 2018. At the time, she was just 20 years old, and she was allegedly raped by someone that she had met on a dating site who had invited her over to his house or premises under the pretense that he was having a party. Of course, when she arrived, she discovered that she was the only one there. And so what the regional court did is that it looked at the subjective test, which is the intent behind, looking at the intent in the case of the accused person. And so, and also looking at whether his version could be reasonably possibly true. What he had argued was that he heard her say something, but it wasn't no. And she says that it was like she was in a trance in that moment. And she froze, essentially. And that's why the testimony, or rather the arguments that were delivered or submitted by the amici in the matter, the friends of the court, was so essential in helping the court understand consent, as well as how victims or survivors may act in a situation where they are confronted with such an instance. And so the applicants also arguing that it is a violent thing that obviously strips women predominantly of their dignity and privacy, their psychological and biological well-being. So that is the personal aspect of this matter. And I think the Constitutional Court will take a great deal of care in handling this matter that affects so many people in our country. But the applicants were arguing that the failure of the statute, that's the Sexual Offences and Related Matters Act, to ensure that an accused person must demonstrate to the court that they took objectively reasonable steps to ensure that consent was given, is something that they say is a failure in the statute in its current form. And so they say when an accused person argues that consent was granted, then they have the burden of demonstrating to the court that, in fact, they took the reasonable steps to ensure that consent was granted. So I think the way Advocate Nasreen Rajab-Budlender, Senior Counsel, puts it is apt. So she says that it's constant questions where, are you okay? Are you okay? I think is an important question to ask, you know. Are you okay? Are you okay with us doing this? Are you, you know, things of that nature. And so that is what they were arguing. But I think she received a lot of questions from the bench of the Constitutional Court in relation to the application of the statute. So the sense is that the justices were asking questions about whether it is necessary to direct Parliament to remedy the defects that they say are there in the statute, or whether it's about the application of that statute in our courts. And so they asked questions. There were several questions from Justice Rogers, Justice Theron, Acting Justice Musi as well, about whether the Constitutional Court actually also has the power to do that. Because what essentially the applicants are saying, according to the justices, is that by saying that there must be those reasonable steps that an accused person must demonstrate to the court, is essentially saying that if they fail to do that, then they are negligent. They were negligent prior to the sexual conduct or the sexual act. Yeah. And you look at, in a lot of our crimes, intent is always a very important aspect of it. If you look at murder, the state must prove beyond reasonable doubt that there was an intention by the accused to commit murder. Without intent, it becomes a different offence and perhaps a lesser offence in the form of culpable homicide. And so the Constitutional Court asking if they have the power to essentially create a new offence, which is negligent rape. I want us to just take a listen to what Justice Theron posed to the applicants.
So, Ron, my immediate question is, what is the alternative for this court, first of all? I don't submit that this court has the power necessarily to create new offences. But the alternative is for this court to find...
Sorry to interrupt you.
Not at all.
If that's the next step. If this court does not have the power to create new offences, then it cannot create a new offence of negligent rape. And we need to answer that question first without looking at the facts of this matter as to how it would affect the victims of rape. We need to answer the question of the power of the court independently first. Does this court generally have the power to create a new offence?
Let me turn this around a little bit. What we bring to this court is what we see as a patent unconstitutionality. And it is the job of this court to declare all conduct and acts unconstitutional.
Oh, Zoleka, you've really done your best to explain what happened there. It's very, very well explained. Thank you very much. I feel as though I was a part of the court proceedings there listening in. All right, so there were 3 organizations that were party to this, and hopefully we'll get that bigger picture from your story that you are going to package for us tonight. For the time being, thank you very much, Zoleka Qodashe.